Well, hello once again. This is the Employment Law Show. Good to have you along again this week. I'm John Scholes. Beside me, Lior Samfiru, co-founding partner, Samfiru, Tumarkin LLP, the most positively reviewed employment law firm in the country. A lot of stuff to get through in the show today, including wrongful dismissal for Canadians. We're going to tell you what that's all about a little later on in the show. Again, it's always an important topic here every week over the next 30 minutes as we discuss various things. To reach out anytime to Lior and his team, 1-855-821-5900, help@employmentlawyer.ca. And guaranteed throughout the show, we will make several references to pocketemploymentlawyer.ca. That is a website crafted just for you. It is full of employment law knowledge, things you need to know as a working Canadian. So reach out anytime. It's anonymous. It's absolutely free. Inside there as well is the severance pay calculator. Again, we're going to be using that tool a little later on in the show, as we do every week. But before all that, we get to the week that was with Lior. How are you, pal? What do you got?
Hey, John, always good to be here, and I have a lot of stuff going on. My gosh, it seems like the last couple of years for me has been relentless. So many new issues, new problems to solve, but that's a good thing because the law is the constant. Regardless of the problem, the law still has ways to deal with it. So if you're dealing with a workplace situation, an employment law issue, there are answers and solutions, and help is available. And that's what we're here to talk about on the show. We do this every week. If your job is in jeopardy, if your boss gave you an ultimatum, if you lost that job, or you think that you're going to have this meeting coming up where the boss is going to let you go, well, guess what? There's something that you can do about it. And it starts by understanding your rights, understanding how the law operates. And we're going to do that today, as we do on every show. And of course, you can always reach out to me to have a private conversation about your matter, about your family's matter, whatever it is. We'll give you that personal contact and personal and confidential contact information on the show throughout it, so stay tuned for that. But as we say, always, week that was is the way we start a situation that came across my desk. So, John, usually when I talk about the week that was, there's kind of a happy ending, if you will. There's an answer that I was able to give that solved the problem. Well, this situation I'll tell you about doesn't necessarily have a happy ending, but what it does have is a very important lesson for all employees. So this particular gentleman who I spoke with recently, during COVID, the beginning of the pandemic, his employer said to him, well, we need you to take on more responsibility. We're going to give you this promotion. And because of that, you're going to be paid a bit more. You're going to have more responsibilities. So you're going to start that soon. And good news, it comes with a new employment agreement that confirms everything. So he was very happy, very pleased, signed that employment agreement. Fast forward a year later. Company says, well, it's not worked out. We thought that this new role is going to be great. It's not worked out. It's not your fault. But unfortunately, we're going to have to part ways. And now we're going to pay you for severance. It's nothing that you did. Oh, by the way, that employment agreement you signed a year ago limits your severance. So now you've been here for 6 years. We're only going to pay you 6 weeks' pay. Off you go. Goodbye. So this person contacted me and wanted to know, is that right? So here's the thing, John. That employment agreement that he signed a year ago had a term that limited his severance significantly. Without that agreement, if he's let go after 6 years, he'd probably be owed about 8 months' pay. 8 months. Because of that agreement that he signed a year ago, he is now limited to only 6 weeks' pay. Now, the sad thing is, beside the obvious, is the fact that when he signed it, he didn't even realize that. He was happy to see that he was getting a couple more dollars an hour, that he's going to get an extra week's vacation, that he's going to have more responsibilities. That's all he looked at, and he didn't realize that that termination clause at some point could, and in fact now is, costing him tens of thousands of dollars. So I had to break the bad news to him, and there's no answer or solution here. But the lesson, I promise there's an important lesson, is this. You cannot and should not sign employment agreements that limit your termination entitlements. If you're an existing employee and all of a sudden your employer asks you to sign a new employment agreement, there's a reason for that. And the reason usually is that that new agreement is better for your employer. It probably contains the terms that limits your severance. That can and likely will cost you a lot of money at some point. Don't sign it. You can't be punished. You can't be threatened. And sometimes it may be better to say no to a promotion if it means you're going to give up tens of thousands of dollars or severance by accepting it. So there's a lesson here, even though the end result for this person, unfortunately, was not a good one.
Can someone in that situation, they might feel weird doing it, but can they just say, okay, hang on, I just want to have this new employment agreement looked at, meaning you? Can they do that to see if it's all good to go?
They can, they should, frankly, they must. Yes. We can take a look at it and in seconds tell you, is this a problem? Is there something here that is going to cost you, that's going to give up rights that you otherwise have? So yes, always have it reviewed. By the way, not just only if you're an existing employee. If you're applying for a job, you got a job, and you've been put a job offer has been put in front of you, have it reviewed. Understand what you're signing. We can also talk about how we negotiate terms. Don't sign something now and realize later that you made a mistake. Usually once you sign it, you have to live with it.
Obviously, we know now, they should obviously go to you before they sign anything. But is there ever a case, I mean, unfortunately it didn't happen in this particular case of the week that was, but is there ever a case where someone brings you that employment agreement and you look and go, this doesn't even legally hold water, regardless of what they signed? Is there ever that sort of case? Someone, maybe an employer grabbed it off of a Google document and thought that was good enough, right?
Yes, and in fact, actually, believe it or not, John, this happens more often than not. That an employer wants to do something that limits an employee's entitlements, but they don't do it properly. It's not properly drafted. They haven't gotten the proper wording in the document for whatever reason. And that means that it doesn't do anything. Now, in this particular situation, it was one of those cases where the document was properly drafted. But your point is well made and a very important one. Even if you end up signing an employment agreement that tries to limit your entitlements, it may not actually do that. So don't assume that it does. Even in that situation, before you walk away from entitlements, let me see it. In many cases, we can get around it, okay? But still, the advice I gave initially is still, I think, the most responsible one, which is ultimately do not sign anything without understanding what you may be giving up.
Again, reaching out anytime, 1-855-821-5900, help@employmentlawyer.ca. And if you just shorten that down to employmentlawyer.ca, the firm website, there's a media section. From that, you'll get radio shows across the country on a bunch of stations. One's got to be near you. Listen online as well. And from those stations, we get tens of thousands of listeners asking phone calls, phoning in every week. And we like to play some good ones that we can learn from here on the TV show, which we're going to do for the first time this week, Lior, right now.
I work as a courier. The pay structure, I get a daily retainer minimum, and the rest of my pay is made up commission on calls that I receive and deliver. 6 months ago, they took away 3 of my best lucrative contracts, so my pay dropped by 40%. So I waited all summer, told me to hold on. They didn't respond to my numerous emails and phone calls. So I would like to know if this is considered constructive dismissal.
Brutal. Wow.
Yeah, so he understands at least that there's this concept of constructive dismissal. He's thinking about it the right way. And yes, this is a constructive dismissal. Now, his job has not necessarily changed. He's still in sales. He still earns commission. What his employer did there is they changed the structure of his compensation, the net result being that he's going to make less money. Well, anytime that happens, yeah, the words constructive dismissal should come to mind. If your compensation structure has changed, your commission percentage has changed, you've been taken, or clients have been taken away from you and replaced with other clients where the pay is going to be less, all those things, if they're going to impact you financially, you have to think constructive dismissal, meaning if you're now going to take less or earn less money, you can choose to treat the situation as a termination of your employment and say, I'm not accepting it. I'm leaving with my severance. Now, the problem for him and for anyone of accepting this, kind of being the good soldier, well, I know I'm going to make less money, but I want to show my employer that I'm the good soldier. You know, obviously that's very respectable. But the problem is by accepting it, you give the employer the right to do it again. So right now they changed the compensation structure is going to earn 40% less. That's a huge amount. Well, what happens if 2 months from now they do it again? Well, because he let it happen the first time, that second time can happen again. So he's right. You should always think about constructive dismissal when something like this happens.
Well, I mean, 40%, that's a no-brainer. That's a big chunk of his income. Do employers have a bit of wiggle room, a little bit of leeway as far as how much they can reduce the pay for whatever reason, economical or otherwise, 5, 10%, without it triggering a constructive dismissal?
So certainly we don't really start talking about constructive dismissal unless the change in pay is more than 10%. So we have to be over north of 10% to be in kind of constructive dismissal territory. So if your pay's changed 5, 7%, yeah, that's not going to make you happy. It's going to make you upset. I understand that and I agree with you. But from a legal standpoint, it doesn't quite rise to the level of constructive dismissal. But the good news is this: if you're not sure if it's a constructive dismissal, if you're not sure if your employer is allowed to do what they're doing, easy. Just contact me. We'll have a chat, and I'll be able to let you know.
Want to go over to terminationquestions.com, yet another website built for you to ask questions, get some answers with Lior. Ron, gracious enough to write in, says, I was fired shortly after asking for time off to handle some health issues. Severance was only 2 weeks' pay after 3 years with the company. They claimed it was the best they could do because I was technically a contractor. What am I really owed? I'm 48 and was earning $80,000 as a consultant.
So, John, there's actually, in this fairly short and simple question, there's so many things to break down. So first of all, he's probably not a contractor. He's likely an employee. You know, if he's been there for 3 years working consistently, he's likely an employee, been misclassified. So something that you have to keep in mind as well, you were likely an employee, even if you think you're a contractor or signed a document saying you're a contractor. If you have a regular job, you're an employee. It's probably as simple as that. Beyond that, he appears to be let go because he told him about a health issue. Well, you can't do that. You can't be let go because you're sick or you're going to need to take off on a disability leave. That's a human rights violation. That's illegal. Can't happen. And of course, the final issue is that of, as we know, he's an employee, as I've said, he's going to be owed a lot more than 2 weeks' pay after those 3 years of employment. How much is he owed? Easy. We can go right now to pocketemploymentlawyer.ca and use our severance calculator feature there, and we can see how much he's owed. And you can do the same thing, by the way, if you are concerned about losing your job. So let's see what our severance calculator shows. We know that this person has been there for 3 years, 48 years old. Our company says we're going to pay you 2 weeks. You're really a contractor. We know he's not, and you can see at the bottom of the screen that he's owed as much as 6 months' pay. Not weeks, but months. That's how simple and how important it is to use that severance calculator, because the difference between what you've been offered and what you're owed can be significant. And by the way, that severance calculator, which of course is available at pocketemploymentlawyer.ca, it's free, it's anonymous, it's extremely simple to use. No excuse not to make that the very first place you go to if you lost your job or are about to lose your job.
We're going to switch gears, start chatting about wrongful dismissal, but first, got to take a short break. We're going to do that now. In the meantime, the number, 1-855-821-5900, help@employmentlawyer.ca. That's the email address. We'll get right back to it. Employment Law Show, stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, welcome back. Employment Law Show. John Scholes along with Lior Samfiru. You want to reach out privately, have a lengthier conversation with Lior and his team. It's easy. 1-855-821-5900. help@employmentlawyer.ca. There's also pocketemploymentlawyer.ca for lots more information about this topic. Okay, wrongful dismissal. Want to get right into this, Lior. For people who have, well, we've mentioned it a couple times in the show. We do every week. That term comes up. Let's start with just breaking it down. Wrongful dismissal does not mean you've been let go for the wrong reason, does it?
It doesn't. So usually a wrongful dismissal has nothing to do with why you've been let go, okay? A wrongful dismissal is not a situation where you believe that the company's lied about the reason or gave you a bad reason. I understand that people very often get upset for being let go. And I completely get that. I would as well. If I didn't do anything wrong, why should I be let go? But the fact that I was let go without having done anything wrong does not mean that I've been wrongfully dismissed. And why? An employer generally has the ability to let someone go at any time and pretty much for any reason, as long as they pay them the severance that is owed. So what is a wrongful dismissal? A wrongful dismissal is a situation when you've been let go and you have not been paid your proper severance or have not been offered your proper severance. Now, a wrongful dismissal is extremely common. Probably 90% of dismissals are wrongful dismissals, not because of the reason. The reason could be irrelevant. They're wrongful dismissals because what the employee was offered is a lot less than what they're owed. That's why it's so important to get legal advice if you lost your job, because chances are, even though the company may be acting in good faith, it's still a wrongful dismissal.
Point number 2 is this, Lior: a significant change in your job can result in that wrongful dismissal, yeah?
So before the break, we were talking about constructive dismissal. We're talking about this concept that because your employer did something, changed your job, reduced your pay, demoted you, changed your hours, that could be a constructive dismissal. Well, a constructive dismissal is a form of wrongful dismissal. If you've been constructively dismissed, you're owed severance. If you didn't get that severance, you've been wrongfully dismissed. So yes, so even in situations where the company didn't even let you go, they could have still wrongfully dismissed you, John.
Okay, so next one is this, again, doing a wrongful dismissal, and this is where everybody gets it wrong. Severance pay is calculated using a bunch of factors. It's not just a week per year, 2 weeks a year, like your uncle or your pal Steve. I don't know why Steve always gets beat up on this show, but Steve might give you the wrong information. And that's just not a fact, is it?
No, it really isn't. So people may say, well, why are you spending so much time when you're talking about severance? Because we know what severance. We could do some simple math, a week per year, 2 weeks per year. Very simple. Why do we have these calculators? I mean, come on, most people can do a week per year in their head. Well, no, it's not a week per year or 2 weeks per year. It's a lot more than that for virtually all people, for most people. How much is it? Well, it's based, as John said, on a number of factors. The biggest factors are your age, your position, and the length of your employment. Longer you work, older you are, and the more senior a position you have, the more severance is owed to you. And if you don't get that severance, that's a wrongful dismissal. So you may be owed, forget about a week per year, you could be owed 4 months per year. You know, for example, you could work for 1 year and be owed 4 months severance, or even more, 6 months severance. So that's why we're here. That's why it's important to understand that you do not accept that severance offer without getting legal advice, because it's not a week per year. And as I said, chances are, if you lost your job, that you actually have been wrongfully dismissed.
We are talking about that this week on the show, wrongful dismissal, what it means, how you can remedy the situation if this happens to you or a friend or a family member. Next point is this, the length of time you have to pursue that wrongful dismissal. Not a pressure tactic. It's not next Friday. It's not a week. You have 2 years to do that, right?
So every severance letter that's ever been created pretty much will have a deadline. So employee, we're offering you this severance, but because we're being so generous, that offer is only open until Friday at 5 o'clock or whatever the day is. So you better accept it, employee, or you're not going to get this extremely generous offer. No, forget it. Everything I just said, by the way, is false, because that offer is not generous. That deadline is irrelevant. As John said, your legal rights don't expire on Friday or on Tuesday or whatever that letter says. You have 2 full years to pursue your entitlements. Your entitlements don't expire. Your rights don't expire until 2 years have passed. Now, I am not saying at all that you wait 2 years. I'm not even saying wait 2 weeks. All I'm saying is take the time that you need and don't fall for that pressure tactic, because once you do, once you sign off on that letter because, well, it gave me a deadline, I felt that I had to, then you realize that was a mistake. I'm owed another $80,000. You can't do anything about it. And I've had to break the news to countless people over the years. Yes, that you're owed much more, tens of thousands of dollars more, but you signed on that paper. You've accepted it. Don't let that happen to you. If you're let go, chances are that's a wrongful dismissal. We're talking about wrongful dismissal. We can resolve it quickly, but you cannot sign off on that offer letter.
And that last point is the final point, really, of wrongful dismissal for this week. Is how do you know? How do you find out if you've been wrongfully dismissed just by a sheet of paper? An employment lawyer can do that for you swiftly and correctly, right?
John, before you even contact me as an employment lawyer, you can find out yourself in seconds. We mentioned it earlier. If you've been wrongfully dismissed, just go to pocketemploymentlawyer.ca. Use the severance calculator. Find out how much you're owed and compare that with what you've been offered. The calculator can even do that for you. It can compare what the law says you should have with what the company has offered you. If there's a discrepancy, that's a wrongful dismissal. You can contact me if you want directly from that severance calculator. Again, at pocketemploymentlawyer.ca. The good news, John, is that these cases, unlike other cases, are not difficult to resolve. They don't take a long time to resolve. And people should not be afraid of the process, should not be afraid of dealing with a company that has a lot of resources. The law here is clear. It's not difficult to pursue. So always reach out if you've been dismissed. Chances are it's a wrongful dismissal.
Again, firm website, employmentlawyer.ca. That is where you'll find a radio station near you that carries our show. We take the phone calls from it, talk about them here, Lior. Phone call number 2 is right now.
One of my coworkers, I assumed he was having a bad day, just started yelling at me, saying that I wasn't pulling my weight. There is a 3-man crew. I went to the supervisor, I let him know about it, and I said, I don't know what his problem is. And then it happened again the following week. Manager's office, I let them know what's the problem and get it out on the table, find out. They did nothing about it.
So, of course, it's up to the employer to take these things seriously, to try to resolve workplace problems, because these things can escalate. And if they escalate, that could cause all kinds of problems and exposure and liability. So an employer should not ignore these workplace conflicts. An employer has to investigate and try to resolve them. So what I would advise this person is make sure that it's in writing, that he contacts the owner, the boss, HR, whoever the right person, and tell them, there's this issue. I've told you about it. You haven't done anything. Please deal with it. Make sure that it's in writing. If the company deals with it and resolves it, great. Best case scenario. If they don't, if they ignore it, that may well be a constructive dismissal. The company not doing what it's supposed to, dropping the ball in terms of protecting the employees and ensuring a healthy work environment could absolutely be a constructive dismissal. But we have to have a way to prove it. That's why put it in writing, make sure that the company understands what you're saying, what you want them to do, and if they don't, you give me a call.
What if you don't get a response? You send an email and nothing comes back to you. You're going to get nervous.
Well, sure, but if the company, if you tell me, please deal with this, and they don't respond, they've ignored you, and at that point, we can deal with it externally. The important thing for me is that there be a record that you've told them about it. You don't want the company to come back and say, oh, we never knew, you never told us, we asked you and you said everything was fine. No, that's why you have to put it in writing. If it's not in writing, it doesn't exist.
All right, guys, short break. Lots more to go. In the meantime, here's the contact. They'll reach out, 1-855-821-5900, help@employmentlawyer.ca, and always pocketemploymentlawyer.ca as well. We'll continue. Employment Law Show, more coming up. People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca. All right, so good to have you along for the last few minutes of the show. Again, employmentlawyer.ca, that's the place to go to find a radio show near you across the country. You can listen to that weekly for an hour, a lot of phone calls. You can even call. There's always a number given out. You can call in and ask your questions as well. As Lior knows, we get a ton of questions every week on all across the radio shows, and we'll play the good ones back here, the interesting ones, talk about them a little more. Phone call number 3 for the day, Lior, is coming up now.
work for a financial institution, and I've been in a management role for 13 years. A few months back, I got a warning letter because of a response to a Instagram post, and now my boss is trying to convince me to take on a different role. He doesn't think I'm suited for the role anymore. Is that something that I have to consider? Telling me that I should take on more of an individual contributor role as opposed to a management role.
Mm-hmm.
So no, he doesn't. Now, unless he did something so terrible, so awful, that it would give the company the right to let him go for cause, which certainly doesn't seem to be the case, because if that was the case, the company would just let him go. Then no, he does not have to accept a lesser role. So here's what's going to happen. He can tell his employer, no, I'm not doing it, thanks, but no. And then either the company backs off and leaves him be, or the company may choose to demote him. If they do that, he may be able to treat that as a constructive dismissal. The company doesn't have a right to demote him. It's embarrassing. It's not something a company can do. If he is demoted, same with you at home. If you're demoted, you can treat that demotion often as a constructive dismissal. Now that means you're owed severance. So one more time, for the last time today, John, let's go to pocketemploymentlawyer.ca and see how much this person would be owed if, in fact, he's demoted, if he's been constructively dismissed. We're going to use our severance calculator, so let's see what that gives us. So we know that this person is in a managerial role currently. He's 54 years of age. He's been there for 13 years, okay? You can see at the bottom of your screen, he could be owed as much as 20 months' pay. That's even though the company is not letting him go. They may just demote him. Because that demotion can be a constructive dismissal, he could be owed as much as 20 months' pay, but there's no reason why he or anyone would simply voluntarily accept a demotion.
Want to go to terminationquestions.com again, Lior, for another question from Ariana. This time says, I just lost my job after 2 months with the company. They said I failed the probation period, but I was never told that there was a probation period. Can I get my job back?
So the first time you hear about a probation period should not be when you're let go, okay? That should be in your employment agreement. So if your employer says, we're letting you go because you didn't pass your probationary period, go back, find your initial employment agreement, your job offer letter, and look at it. If it says you're on probation, if it says you're on probation for 3 months, and during that time, we can let you go by paying you nothing, if that's what it says, then yes, your employer can let you go during that period of time and not pay you anything. If it doesn't say that, then there's no probationary period. A probationary period is not automatic. There's no probationary period. It doesn't exist unless you sign the document that puts you on probation. And even after 2 months of employment, you could be owed a month, 2 months, 3 months of severance. So it's important to understand that. Just because the company says you're a new employee, you're on probation, we're letting you go, does not mean you're on probation. Find that employment agreement. If you don't find it, if it doesn't exist, if you didn't sign it, or if it doesn't say you're on probation, then you're not on probation.
Can they extend it after 3 months if you are? And do they still have to pay you?
The reality is that the only period of time during which you can be let go without compensation is 3 months, the first 3 months. But again, only if you sign an employment agreement that says that. So no, a company cannot, practically speaking, increase or lengthen the probationary period, because if they let you go after 3 months, they have to pay you your severance. So don't assume that just because you're a short service employee, you've worked there for a few months, severance is little. PocketEmploymentLawyer.ca, our severance calculator tool there, works just as well full-time, part-time, service, or long service. First place you go to if you lost your job.
Great show again today. Lots of information there. Reaching out if you're confused or want more. 1-855-821-5900. help@employmentlawyer.ca. And as Lior said, pocketemploymentlawyer.ca as well. We'll see you again. Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.